This matter is before the court on the defendant's motion for modification of parenting time. Ms. Nickerson.
Thank you, Judge. I really don't have much to add beyond what's in the motion. The parties have a 10-year-old daughter. They have an order of joint legal custody, and the last order that had entered provided for plaintiff father to have sole physical custody. And then there was a parenting time schedule that was put in place, and that was based upon drug testing of my client. And she had successfully completed a year's worth of drug screens as outlined in that order. And so because of the order, they had gone back to a parenting time schedule, but even though it wasn't called joint physical custody, she was back to doing 3 overnights per week. And that had continued until the spring of 2020, when plaintiff had produced his own screen that regrettably the defendant took. I don't even know if that screen was sent for actual confirmation, but dad had screenshotted her a picture showing positive screens. She then tried to cure that by seeking advice of counsel and going to prompt care for drug screens after that, but the parties were not able to get back on track. In April of 2022, my client's relationship with the plaintiff's significant other, his wife, started to become close. My client was able to have unsupervised visits again with Mariah. She was able to take her unsupervised out of town for a weekend. That was really the first visit and was very enjoyable. And then thereafter was able to do parenting time consistently, but each week it was reliant on my client and plaintiff's wife being in touch to figure out what the schedule should look like and be for that week. There was a disagreement between the ladies, and that occurred over Halloween of this past year. And the two women are the primary ones to make the arrangements for this parenting time. My client hasn't been having a lot of contact directly with the plaintiff to arrange visits. And after the disagreement between the ladies, the visits stopped being allowed. And so my client sought my counsel to file a motion to have the orders changed or corrected. My client has been able to still see the minor child at her basketball games on Saturdays, and the contact between the ladies is still limited. But I don't even bluntly know, as I stand here right now, if the motion's contested. My client and the plaintiff were able to speak very briefly at some point during this last weekend's basketball game. And she says that Mr. Powell just had said, well, we just wanted more communication. And so we just feel at this point we need an order to reflect something that's more along the lines of what the parties were doing. It wouldn't, though, be going back to what that order from 2018 said. My client is recognizing at this point, Mariah is in Battle Creek primarily. My client has a work schedule that would allow her to do parenting time every other weekend from Friday at 6 until Sunday at 6. She would also like to have parenting time one evening per week, alternate weeks in the summer, and standard holidays to include a division of Christmas break, alternate spring breaks, and alternate the rest. We would ask that it be specified that any restrictions regarding supervision of my client's visitation would be removed. And I think at this point in time, based on what's happened since 2018, that there isn't a basis to continue to have this drug screen provision in the order. The way that 2018 order was worded, it kind of continued forever, but after a year was more at the whim of the plaintiff if he just requested a drug screen. But I think this family is past the point of believing that that is a concern. If the court does believe some type of drug screening is required, we would ask that it be reasonable and that it be screams at a facility, that it wouldn't be a scream by Mr. Powell, and that there be some kind of length of time when it would end after so many successful screens. And so that is our request for relief for
Okay,
today.
thank you.
I would like to stick with the order that was determined back in 2018. I am not willing to modify. And the reason for this being is back when I brought that drug test to her in, what'd she say, 2020, she had successfully completed, but her communication was getting more sporadic again. She was texting us from random cell phone numbers, asking us to use our minor child's iPad for communication. Consistently could not pick her up or drop her off, and so we would do that. And so in the order, it says that, if reasonable suspicion, I can ask her to take a drug test. I asked, she did not want to pay for one, so I asked her if I bought one, would she take it? She agreed, and that is the at-home drug test that we then had. She then went to prompt care because in the order, when she takes a positive drug test, she was supposed to do another, 12 months clean, 2 screenings a month. From what I have, she took 5, is what I have on file of clean screenings. And then a defendant actually disappeared for 22 months. So she did not see the minor child, did not reach out for contact for 22 months. She made a call to us just saying hi, told us that she was pregnant with her new daughter. And that was kind of that. She ended up reaching out again, wanting for Christmas time. And I said, hey, that has to be supervised. She did not like that, kind of cussed us out and hung up on the phone. And we just kind of ended up getting in communication again up until April of 2022, when she was pregnant. And then communication started picking back up. Things were great. We could see that she was clean. And so I had no problem with her seeing the minor child without supervision because I was confident that she was clean. Now, with her prior record after Halloween, there was a little bit of incident. I guess she thought my wife was irritated. We were down there in Union City. My parents live there. Her friend lives there. And so we were just going to kind of meet up for Halloween. We spent a lot of time running from house to house. We weren't walking as the defendant was with her friends. And so I'm not sure if some confusion, I'm not sure what happened there. But anyways, there was some irritation. I know some texts were exchanged between her and my wife. My wife just apologized for seeming irritated. And then I know we had agreed upon a time where the defendant was going to pick up the minor child from school. However, 9 days previous or 9 days leading up to that, we couldn't communicate. We didn't hear from the defendant. We reached out to her multiple times. Hey, is this still good? Hey, is this still good? No response. And so we made other arrangements for our daughter to be picked up because we hadn't heard anything. And with past experience, this lack of communication starts to signify bad signs. And so we told her, she finally reached out the day of. We told her we'd already made other arrangements because we had not heard. We got cussed out on the phone, hung up, and then we did not hear from her again until I think it was December 21st or December 22nd, wanting time on Christmas. I said, yes, but it's going to have to be supervised because we haven't heard from you in a month and a half. And we just go from there. Defendant doesn't want to communicate with us to let everything know it's okay. I haven't been unreasonable with drug testing. I'm not just asking her to randomly take drug tests. If I think there's reasonable reason for her to, lack of communication, starting to, having a lot of issues with picking up the child or dropping off the child or things like that, I start to get suspicious. But I haven't just been asking her to randomly take those drug screens. Those drug screens are in place because of a history that she has shown, and I do not think they should be removed.
Okay, thank you. Well, what the court was going to do in this matter is that we don't have an agreement. The court's going to refer the matter to the referee for an evidentiary hearing, and you'll be contacted and they'll have a hearing on that. Again, court will note the appearance of Mr. Bowery on behalf of the plaintiff, Mr. Todd on behalf of defendant. This is before the court on the defendant's fourth motion to hold plaintiff in contempt. Mr. Todd.
Thank you, Your Honor. Your Honor, in this case, the parties have joint legal and joint physical custody. The court's pretty well aware of these proceedings. Additionally, they have a phone call set for 15 minutes every other day when the children are with the other parent, starting at 7 p.m. Additionally, per the child support order and calculations, the plaintiff and mother is to carry insurance on the minor children. On December 2nd of 2022, plaintiff was a half hour late dropping off the children. And while this may be considered petty to a certain extent, if it was the other way around and Mr. Brown was 30 minutes late picking up the children, his parenting time would have been forfeited. There was no phone call or any communication to relay that message. On December 19th, defendant emailed the plaintiff requesting insurance information as one of the children had, in essence, a toothache. No information was provided. The same question was asked the following day. Again, no insurance information was provided. Subsequently, Ms. Brown did indicate that she had insurance, but she would be the one who would set the appointment, and she still failed to provide the insurance. It's our understanding that the insurance still has not been given to Mr. Brown to date. Plaintiff also previously failed to give the insurance in April of 2021 as well. In terms of the phone contact, again, that's supposed to occur at 7 p.m. For 15 minutes. This is the fourth show cause motion, but I believe at least the second time this has been brought to the court's attention. The defendant still needing to call multiple numbers to find the children. He'll call Miss Brown, then her mother, and then her sister to find the children, and they often are not there at the designated time. For example, defendant was denied phone contact again on October 20th of 2020. Additionally, he was denied phone contact December 11th, 2020 at the designated time. We don't quite know what to do, honestly, other than continue to file motions to hold her in contempt. We are respectfully requesting plaintiff be held in contempt. We are requesting makeup parenting time of an additional 30 minutes to be made within 30 days at my client's discretion. And we are requesting, I guess, that plaintiff be required to have the children with her at the designated time of 7 p.m. Additionally, we are requesting all insurance information be provided today. And we do believe sanctions are appropriate. We are requesting attorney fees associated for filing this motion, which is the fourth motion to hold her in contempt.
Okay, thank you. Mr. Bowery, what's your response?
Yes, Your Honor. In response to the allegations, on December 2nd of last year, the defendant contacted plaintiff by phone numerous times. The minor child called the defendant and informed him that the parties were running late. The reason the parties were running late is because the plaintiff was braiding the minor child's hair. On the way to the location, they picked up food and made a stop to use the restroom. This resulted in the parties being 15 to 20 minutes late. And in addition to that, Ms. Brown did send father a follow-up email at around 7:24 p.m. I attached this as an exhibit. It's marked Exhibit A. In regards to paragraph 5, the allegations on December 19th and December 20th of last year, Ms. Brown did respond to father's emails. In addition to that, Ms. Brown did contact the dentist to inquire about open dates for the minor children. Ms. Brown has responded to father's emails in a timely manner to the best of her abilities. In addition to that, Your Honor, father never contacted the dentist office. The defendant did not take the minor children to the dentist to have the minor child's swollen jaw examined. Furthermore, Ms. Brown offered to take the minor child numerous times as the defendant was occupied elsewhere. The minor child was eventually taken the following Tuesday and sent father updates via email. In regards to the insurance information, we believe that father has this information and is readily available to him. The doctor and the dentist treating the minor children have been the same for at least the last couple of years. Mother always responds back to father in a reasonable time frame. In addition to that, she's allowed him extra parenting time on numerous occasions. So we would ask the court to deny defendant's request to hold a plaintiff in contempt. We're open to additional parenting time. And if this information regarding the dentists and the doctors needs to be released, then we have no quarrel with that. But we would also ask the court to deny defendant's request for sanctions as well.
Okay. Well, what the court's going to do is the court's going to order that the plaintiff would provide the medical, dental, and a vision insurance information to the defendant through his attorney's office within 7 days of today's date. Court would also order that, again, if the plaintiff is late for the child exchanges, for example, if she shows up at 6:45, then the following, when the defendant returns the child, he doesn't have to return them until 6:45. So however long she's late, then he gets that comparable time before he has to return the children. So court would also order that the phone calls would occur as ordered at 7:00 p.m. The defendant will provide a number to the defendant where the children can be reached, and they will need to be available at that number when he wishes to call them. The court will then will reserve on the attorney fees at this particular time. Mr. Todd, you can prepare that order and submit it under 7 day.
Thank you, Aaron.
Okay, thank you. That will conclude this matter at 9:27 a.m. You're free to go. Have a good day.
Thank you, Aaron.
I'll just say before we start, Mr. Volmering, it looks like you're driving. I'm not going to have a hearing when you're driving and potentially cause an accident. So pull over or do something so that you're not distracted. And you're muted, Mr. Volmering.
I am pulled over now. Thank you. Sorry about that.
Okay, so.
Court will note the appearance of Ms. Podolsky on behalf of the plaintiff in this matter. This matter is before the court on the plaintiff's second motion for post-judgment relief. Question I had, Ms. Podolsky, in this is there was reference to the dance classes, recitals. Are those all on defendants' weekends or?
I think it varies. It just depends on when the dance studio schedules them. But it worked out previously where we were here on one other time on this issue where it happened to be on his weekend. And this year it's going to be on his weekend as well. So in the event that this continues to happen where the dance studio schedules it and it happens to occur on defendant's weekend, we're just trying to address this ahead of time.
Okay, go ahead.
Thank you. There were several issues that we outlined in our motion. The first being our family wizard. I will state the defendant did start to use that after receiving this motion. So we're just asking the court to continue that order, that is the method of communication these parties are to use. Transportation, that continues to be an issue as defendant continues to drive the minor child without a driver's license, without an appropriate car seat. The parenting time exchanges are to occur at the Battle Creek Police Department. There has been times when my client has accommodated an alternate location for defendant. Unfortunately, when that happens, he takes those opportunities to verbally berate her. So we're asking that it continue to be at the Battle Creek Police Department. We're asking for an exchange time be set. There is not one in the judgment. We believe that will be necessary due to the issues that these parties have had. We're asking for 5 p.m. As previously discussed, this minor child is in a dance class. And on the days when that dance class occurs and a parenting time exchange is required, we do believe the dance studio would be appropriate. It's a public setting. Other people are present if something were to occur. We have addressed this issue of the dance class. We're asking that anytime there is a rehearsal or a competition or a performance that happens to fall on defendant's weekend, we're asking that those weekends be swapped, that that weekend be awarded to the plaintiff so she can ready the minor child for that performance or competition, and defendant would have the weekend immediately following. There has been an issue with clothing. My client spends significant money on clothing for the minor child. She is not getting that clothing back. There have been times when the defendant has thrown clothing away as purchased by the plaintiff. So we're just asking the court to direct both parties to return clothing and personal property purchased by the other parent at parenting time exchanges. Medication and health-related issues. There have been instances where the minor child has been prescribed medication that defendant is not providing during his time. Most recently, that was an eardrop and antibiotics when the child blew an eardrum. Those were returned to plaintiff, having not been administered. Further, the minor child has been regressing in potty training as the defendant is just putting her in a pull-up diaper rather than addressing potty training issues, which at this point at her age are important, that these need to be addressed. She should be potty trained. Legal custody issues, we are having concerns. It's when the minor child is dropped off at her schooling program, she is becoming hysterical. She's crying. She's not wanting to leave plaintiff, using words that she's afraid plaintiff is going to abandon her. These are words a 4-year-old doesn't know. We are concerned that the defendant is talking to the minor child about the parties' relationship and parenting to her, and not encouraging a relationship between plaintiff and the minor child. All of these issues, Your Honor, can and should be addressed through co-parenting counseling. These parties have been ordered to co-parenting counseling. It has been difficult to find a counselor. Most folks are booked up with waiting lists. However, my client has found a counselor who is willing to work with these parties. She is a Christian-based counselor. However, she does not necessarily need to bring that focus to their counseling if that is not something these parties want, but she is somebody who's available now to work with these parties. If they were in this counseling together as previously ordered, we probably wouldn't have had to be here today with these issues. Again, these are all things that could be addressed in counseling. So we're asking the court to order that counseling. The counselor that my client has found is Susanna Warren, and we're asking the court to order that to begin immediately.
Okay. Mr. Arnold, what's your response?
My response to this, Your Honor, respectfully, is I believe that the plaintiff is making continuous allegations that are completely false, and this is not the first time that she has done this. In no way, shape, or form have I ever spoke poorly about the plaintiff around or about the minor child involved in any way, shape, or form. I actually strongly encourage positive relationship between her and her mother, as I believe all children need both parents involved. As far as the driver's license goes, I've been a licensed driver now for a little while, since prior to this motion being set. The plaintiff had addressed a concern that I was driving around without a driver's license at one of our pickups, in which I explained to her that I am doing absolutely nothing illegal nor unsafe. She kept persisting with the issue. I expressed again, I'm doing nothing illegal nor unsafe. And now here we're here discussing this when I have a driver's license I can provide. Me having a driver's license is actually required for my employment. So if I don't have a driver's license, I become unemployed. As far as the car seat issue goes, my daughter is in a FAA approved, steel reinforced 5-point harness in a legal vehicle with full coverage insurance with no concern for safety. I have all forms of insurance that you could possibly have for a minor child, including health insurance, dental, vision, hearing, and life insurance. As far as pickup and drop off times go, the plaintiff has made concerns to me that allegedly, according to her, I make her feel unsafe, which I don't understand where these allegations come from. I've done nothing but try to be reasonable with her from start to finish, including dating back all the way to when the separation originally occurred, in which I offered to allow the plaintiff to continue to live with me for at least a year, in which she chose to leave and live in a RV in her parents' driveway. In regards to the medicine, not once did I miss giving her medicine. I administered it 100% based on what doctor recommendation and prescription had stated. There was leftover remaining. So the leftover remaining went with the child back with her plaintiff. It did go back a little bit late, as I did forget to grab it to send it back with her, but we met up and it was returned. Another issue with the medication is the plaintiff had been self-administering Benadryl to the minor child without doctor's note. I had requested for information about it. The plaintiff refused to provide it. I did some looking into it myself, found that Benadryl is one of those things that is not healthy to be prescribing to a minor child unless it is for allergic reactions, including hives, or prescribed via a doctor I addressed these concerns with the plaintiff. She immediately began to raise her voice at me inside the lobby of the Battle Creek Police Department. And so at that point in time, I needed to go take my insurance information for the minor child to her doctor's office. Upon doing so, it was brought to my attention that there was a doctor's appointment scheduled for her in which I was never notified about, or the concerns of why she had this doctor's appointment scheduled on February 3rd. And I got in writing from her doctor saying that we are not supposed to be giving her Benadryl unless it is for allergic reactions, including hives, or prescribed by the doctor themselves in writing. I sent this information over to the plaintiff. Another concern that we had was getting my daughter in for dental. The reason that came up was because I was trying to make sure all my insurance stuff that I have for my daughter was on record to the appropriate locations. The plaintiff said that she was having something set up for our daughter to see a dentist. I asked for the information. The plaintiff said that she doesn't have an appointment scheduled. Instead, was just going to take her with her to her dental appointment. At that point, I expressed to the plaintiff that if she didn't have anything scheduled or anything like that, or couldn't provide information, I was going to take it upon myself to ensure that it was scheduled so our child would have appropriate dental care. Within an hour after that, she had a dental appointment scheduled, and I immediately sent the information over. As far as the clothing aspect goes, as it is noted in the plaintiff's motion, my washer and dryer currently does not work. However, we do use laundromats to be able to resolve this issue. The minor child is not fully potty trained, as they are trying to claim. She does have accidents from time to time, to the extent that even the school has planned on occasion to have pull-ups or diapers for her for nap time. So the biggest issue as far as the potty training goes is sometimes the minor child will poop herself or whatnot. So when that occurs, sometimes that's in the underwear. The underwear that I purchased that I throw away instead of letting fecal matter fester in her clothing to completely ruin. So at that point, yes, I throw away clothing, but I throw away clothing that I purchase, and then I replace it as soon as possible. And then all of her clothing that is not ruined via fecal matter as soon as possible goes to the laundromat. The plaintiff is requesting for reimbursement for things in which I am currently in an active Chapter 13 bankruptcy, as noted in the paperwork that I filed for an answer.
Okay. Well, what the court's going to do is obviously there's a number of disputes. There's not a dispute as to the parties communicating through our family wizard, so the court will continue and order that. Sir, do you have any opposition to exchanging the child at 5 o'clock?
Yes, I do. I would prefer to keep it at 3:15 inside the lobby of the Battle Creek Police Department for multiple reasons. One of which is the plaintiff makes the claim that, or has not made the claim to the court, but has made the claim to myself that I allegedly make her feel unsafe. Again, I'm not entirely sure where that comes from, as I've tried to be as corrigible. And
well, you can still exchange at 5 o'clock at the police station.
The lobby of the Battle Creek Police Station is not open at 5 p.m. So if we're going to have to do it at the police department, for more eyes on the situation to be able to help ensure that everything stays cordial and civil, I would prefer for it to be inside the lobby of the Battle Creek Police Station.
Okay. Do you know what time they close that?
I believe it is 4 o'clock, but we have other children that reside in this home that utilizes the vehicle that we have that must be picked up by 3:50, which is why I had explained to the plaintiff in the past that I would like it to be done at 3:15 to ensure appropriate transportation for all children involved.
Okay. Ms. Podolsky, is there any problem with 3:15 exchange time?
We just don't believe it's necessary to be in the lobby of the police station. We believe the parking lot is fine. The minor child does not need to go into the police station for an exchange based on work schedules, school schedules. We believe that 5 o'clock in the parking lot is appropriate.
Well, why don't we try? We'll try at 5 o'clock p.m. to do the exchange in the parking lot. It is recorded, sir, so that we'd have access to again a video if we need that. The court would order that the defendant would provide a copy of his driver's license to Ms. Podolsky's office within 7 days of today's date. That each of the parties would return the clothing of the other party at the parenting time exchanges, that the court would order the co-parenting counseling to occur at the counselor that the plaintiff has identified, and each would pay 1/2 the cost of that. And I think that would take care of most of those particular items at this particular time. And again, if it doesn't, then the parties can file a subsequent motion to address that, but hopefully with counseling and all of that. I know that there's a number of other disputes, but the court believes most of those will probably get resolved through counseling, et cetera. So that will be the order. Ms. Podolsky, you can prepare that, submit under 7-day.
Your Honor, are you not ordering on the dance recital weekends then?
I'm not going to order that at this particular time.
Thank you.
Court will conclude this matter at 9:55 a.m. You're free
We
to
don't-
go. Have a good day.
Oh, wait, I got court. Oh, real quick. I've been waiting on Zoom. Yeah, I can just wait a second.
Court will note the appearance of Ms. Podolsky on behalf of the defendant. This matter is before the court on the defendant's motion to determine financial issues. In this particular matter, court will note that we have a settlement conference scheduled at 1:30 today. I'm hoping to take care of that this morning as well. Ms. Nelson, Ms. Podolsky has asked that the security deposit check be utilized to pay marital bills, and she identified a number of those in paragraph 6 of her petition. Do you oppose that?
I don't agree with that.
Okay, and why is that?
Because all those debts are like Andrew's debts. Like, I'm not asking him to pay my debts.
Okay, well, clarify if you could, Ms. Podolsky, what's the issue on the debts?
Thank you. The issue is, Your Honor, these parties have this refund check in the amount of $1,126.75. It was a security deposit for the marital residence at lot 145. The debts include the Semco Energy gas bill for that address, the Xfinity cable bill for that address. The parties also had a Rivertown Credit Union credit card that they used during the marriage and a Kohl's credit card that they used during the marriage. They do have minor children together. So we're asking that this refund be used to apply to those marital debts. If there's anything left over after the debts are paid, it would be split between the parties. If there's nothing left and debt remains, then we're just asking that that debt continue to be split 50-50. This was all marital. 2 of these are, again, specific bills to that marital residence.
Okay, well, were they to the marital residence when the parties were together?
Yes,
Okay,
my client moved out in October, and I believe the defendant moved out in, or excuse me, the plaintiff moved out in November, so very close to each other.
okay. Ms. Nelson, what's your response?
The 2 credit cards, the Rivertown and the Kohl's, are in Andrew's name. Like,
Well, it doesn't matter whose name they are. Were they incurred during the marriage for marital, again, expenses?
I do believe so.
Okay. Well, what the court's going to do is the court is going to order that the security deposit check would be signed by both parties. That would be deposited in Ms. Podolsky's trust account, that those marital debts as identified in paragraph 6 would be paid from that particular check. And if there is a balance, that it would be divided 50-50 between the parties. Ms. Nelson, if you are disputing any of those bills and you have documentation or evidence to establish that, you can provide that to Ms. Podolsky, and then we'll have to address that at that point. But if you don't provide that within, let's say, 10 days of today's date, then she'll just make payment of that after the check goes through her trust account. Order and submit under 7-day.
I will, and Your Honor, as to the settlement conference, all other issues, real personal property have all been decided, child-related issues have been decided. There is a current temporary order that would be incorporated in the judgment of divorce. So we will submit today's order under 7-day and then notice of a judgment for presenting.
That's
consistent with that
fine.
order.
We'll dispense with the settlement conference. You don't have to come back. Defendant, we have two motions, the plaintiff's motion to change parenting time and defendant's motion to change custody. Who wants to go first?
Well, I think I filed mine first, so I'll go
Okay.
first, and then I guess I'll try to deal with both of them just for judicial economy. Your Honor, we filed a motion to change parenting time from an order from 2015 when the children were 1 and 3. Obviously, their needs and requirements are different. I think there needs to be changes, and I had suggested what the changes should be. Reviewing the answer to that, I think the opposing counsel agrees there have been changes in circumstance, and the court needs to deal with that. I think we disagree on what the changes should be. So I think that motion needs to be subject to an evidentiary hearing. In relation to defendant's motion to change custody, I guess I take exception to that. I don't think that even the pleadings rise to the level of the VARCA change, Your Honor. If you take the motion by itself, there's nothing there. And I think the pleadings are inappropriate in relation to the court rules of saying, oh, see my brief. And the brief is a mixture of law and argument, basically argument. But even if you take all of that information in the brief as true, it doesn't rise to the level of a substantial change of custody. I submit that that motion was filed merely for retaliatory purposes, and I would ask that that motion to change custody be denied at this point in time of not rising to the level of the VARCA, and set the parenting time for an evidentiary hearing. Thank you.
Thank you. Ms. Elaine?
Good morning, Your Honor. I agree with Mr. Schaefer that we both agree that there has been proper cause or a change of circumstance since the original order entered in 2015, which are sufficient for this court to investigate and hold an evidentiary hearing with regard to what, if any, terms of the order should be changed. I don't think it's important at this juncture whether Mr. Schaefer and I agree on what constitutes the proper cause or change in circumstance, because as this court knows, once an evidentiary hearing is held, it is compelled to make findings on the best interest factors and make rulings that accord with the children's best interests with regard to all of the evidence that was presented. Your Honor, I've never been criticized for filing a brief before. It was a first for me. And if there's some sort of special procedure locally that Calhoun County does that I'm not aware of, I'm more than happy to remediate that. But I filed a brief in order to be helpful and to comply with the court rule that says if there's a legal issue, we should supply a brief. To conclude that even if all of our facts are true, they don't rise to the level of proper cause or change of circumstance is a little mind-boggling to me. I believe that they more than meet the threshold, the highest threshold there would be to move forward with an evidentiary hearing. I would also want to note for this court, Your Honor, that it's disingenuous at best for Mr. Schaefer to say this is a retaliatory motion. These parties were ordered to mediation to resolve some outstanding issues that are pending before the court. And in our mediation brief, we signaled that we would be filing a motion to change custody. And it was after that that a motion got filed by Ms. Tabaka. So it is not true at all that our motion was retaliatory. And I felt that point important to note.
Okay, thank you. Anything else, Mr. Schaefer?
Nothing further, Your Honor, but I would just ask the court to review all of the allegations and to make a determination at this point in time in relation to VARCA. Obviously, this the items that are indicated on the change of custody are basically 4 items. And the 4 items have to do with not getting along well enough to make decisions, things about argument of something that happened back in 2021, a complaint by defendant in relation to whom the plaintiff is dating. Things of that sort just don't rise to the level of Bavarka. And I would ask the court to review that. Thank you.
Okay. Well, the court does note that the parties are disputing many items, and I did have a chance, and I did review Ms. Elaine's brief, which more fully set forth some of those allegations. And obviously, it may be proven at an evidentiary hearing that they're not accurate or not, sufficient, but at least for purposes of determining whether we go forward, the court does acknowledge that if proven, that would provide the proper cause and change in circumstances sufficient for an evidentiary hearing. And the court's not going to weigh it this time, is not going to weigh the impact, if you would, or the weight of those particular allegations or proofs. So the court is going to refer the matter to the referee for an evidentiary hearing on the issues of parenting time and custody. And you'll be contacted, and they'll set up a time for you to present your cases at that point. Court will note the appearance of Ms. Reed on behalf of the defendant and the appearance of Mr. Magnuson on behalf of the front of the court. This matter is before the court on the defendant's amended motion to set aside default judgment. Ms. Reed.
Thank you, Judge. For some background, the friend of the court through the Child Support Establishment Unit brought a complaint for custody and in fact held a hearing on entry of a default judgment in regard to that complaint. There was a hearing held on December 16th in which my client appeared in order to try to participate in this proceeding. And despite his appearance, the referee entered the default judgment anyway, which granted the plaintiff sole custody of this minor child and no parenting time schedule for the defendant. Pursuant to MCR 2.603D, we filed a motion within that 21-day period in order to set aside the default judgment and have my client be allowed to participate in the case that involved parenting time and custody of his one-year-old child. My client has good cause and a meritorious defense in order to set that default judgment aside. The good cause being that he did appear at the hearing, he attempted to participate, and in fact, despite that, the order entered. In regards to his meritorious defense, we make several allegations that we're happy to flesh out if this court were inclined to schedule an evidentiary hearing. At the time that that order entered, the parties were still residing together. So that is an issue that my client would like to deal with. Furthermore, we have a lot of concerns about this child being in the custody and certainly in the sole custody of the plaintiff mother because of issues with excessive alcohol consumption that have caused Children's Protective Services to become involved. In fact, I've spoke with the caseworker, Megan Titus, several times. It's a Category 2 case. They're attempting to get services in place and have the mother's participation. And up until very recently, I don't even think she was communicating, allowing CPS any access or anything to that extent. And so we're here today asking for your honor to set aside that default judgment so that Mr. Winters can participate. It's worth noting he is a very involved father with these children. He has parenting time with them. He takes them to their doctor's appointments. And so it is not in the best interest of this child who's 1 year old for him to not be allowed to have any access and for plaintiff mother to have sole custody of this child. And I've said children because there's actually a new baby who's just a little over a month old that we've also filed a complaint on as well. So thank you.
Okay, thank you. Mr. Magnuson, enlighten me what happened, if you know, at the referee hearing and entry of the default judgment. And
thank you, Your Honor. I think Ms. Reed has stated things correctly as far as how these things went procedurally. We did file this case back in August. Service was made on September 27th of last year. No response to pleading was filed at all, so a default was properly entered on November 18th of 2022. We did prepare a default judgment and notice it to both parties. That went out on November 21st of 2022. A hearing was conducted at that time because of the nature of this, because there was a default, no answer had been filed. The referee did not take testimony, but approved the proposed order for entry. So I just want to emphasize that everything in this case, from a procedural aspect, was done correctly. That being said, I do not have any objection in the spirit of getting things correct to have this set for some type of evidentiary hearing, whether it be in front of your honor or the assigned referee, and having some testimony taken based on the defendant's representations, and we'll see how that plays out.
Okay. Ms. Miller, what's your response in this matter?
My response is, first off, I never received a letter to go to court. You guys have my address wrong for 517. I'm 506. CPS is only involved into my children's life because of a domestic violence that me and Frederick had. It has nothing to do with alcohol consumption. As far as him being an active father, yes, he is an active father. Yes, he do take care of his children. On the other hand, CPS is only still involved in my life right now because I wanted my daughter to get counseling. She has anger issues. Other than that, my case was closed.
Okay.
So anything that's being said as far as my CPS case is not accurate.
Okay, well, it sounds like there's some issues here, and obviously those would be ferreted out if we had a hearing. I'm not going to set aside the default judgment at this point, but I am going to refer the matter back to the referee for, again, a hearing as it relates to, again, custody, parenting time, et cetera. And then we can have a hearing, and again, we'll be able to ferret out all of those particular issues at the time of that particular hearing. So court will do.
Well, Mr. Winters had already discussed all this, so he's not willing to continue on with this either. So,
well, that's fine. We're referring it back for a hearing. You should get notice of that, Ms. Miller. If your address is not accurate with the front of the court, you're going to need to go to the front of the court and change the address. There's a form you can fill out in the lobby, which is a change of address form. That way you'll get proper notice, okay?
Okay, and I also have there's a sheriff officer that comes out and serves me hand to hand, face to face. So I'll get everything from here on out, but I didn't get a notice for a hearing on January, and I didn't get one for December either.
We don't know about that, but court will end this matter at 10:26 a.m. You're free to go. Have a good day.
Yeah, you too.
Judge, I'm assuming, is that just a referral order? You don't need me to prepare anything?
No, we don't need you to prepare anything. We'll just do the defendant. This matter is before the court on the defendant's motion for temporary custody, support, and parenting time. Mr. Umloff.
Your Honor, the parties have one child in this case, Nevela, age 9. The child lived primarily with the plaintiff's mother, Renette Dilling, who was the child's guardian until her powers were suspended in June of 2021. My client learned that the plaintiff recently moved the minor child from Ms. Dilling's home in Battle Creek to a new location in Marshall. The new home does not have adequate sleeping arrangements for the child. My client had been exercising parenting time on a schedule of alternating weekends since June of 2022. However, after Christmas, the plaintiff and Ms. Dilling stopped letting him see the child. What we're asking for today is that the parties on a temporary basis share joint legal custody, with my client having parenting time on a schedule of alternating weekends and alternating holidays until the court can make a final determination as to child custody and parenting time. And of course, child support in accordance with the Michigan Child Support Formula. We do have serious concerns regarding the plaintiff's history of erratic behavior and drug abuse. But we also recognize what the status quo was and would ask that the court continue that while we are awaiting a trial in this matter. Thank you.
Okay, thank you. Ms. Gillard, what's your response to the motion?
Your Honor, I didn't abruptly move my daughter out of my mother's home to Marshall. He knew on September 19th of 2022, I have it written down, that we had a phone conversation about me moving Nevela here to Marshall with me because I am able to take care of her like I'm supposed to. She has her own room and her own bed, so she has very good sleeping adequate. I did enroll her into school here in Marshall, and she is enrolled into extracurricular activities, as in Girls on the Run. She's getting ready to do gymnastics. I did abruptly stop letting him see her because he stopped communicating with me about my daughter on any type of communication at all. He wouldn't talk to me about anything. So I just wanted it to be on paperwork that he can't keep her from me because he does have a history of keeping her from me. Also, Your Honor, I do want to bring up, I did have a past of drug abuse, but July 2021, I was released from being incarcerated, and I have been clean, and I have been doing everything I have to do to be a mother to my child.
Okay. Well, at the point, this is just a temporary order. The court will continue the kind of the status quo, which is the physical custody will be with the plaintiff in this matter. Court doesn't have any problem with the parties having joint legal custody. That just means that the parties will discuss important decisions concerning the child. You may not agree, but you have to discuss those. If you can't agree, then bring the matter back before the court. The court will give the grant to the defendant standard parenting time commencing this Friday, February 17, 2023 at 6:00 p.m. through Sunday at 6:00 p.m., as well as a midweek, which is every Wednesday from 4 to 8 o'clock, as well as standard alternating holidays, alternating spring break, half the summer, etc. Child support will be set consistent with the parties' income, and the parties will exchange their income information within 10 days of today's date.
Okay, and where do I turn that into?
To Mr. Umloff's office.
Okay.
Okay.
Yep.
Mr. Umloff, you can prepare that order and submit it under 7 day.
Thank you, Your Honor.
Okay, thank you. You're excused for now, and have a good day, and the court will end this hearing at 10:33 a.m.
Thank you.
Court will note the appearance of Ms. Podolsky on behalf of the defendant. This matter is before the court. I think on plaintiff's motion for enforcement of delinquent military or marital debt payments. I did receive the answer in this matter, and the answer says that the defendant's prepared to pay. Ms. Podolsky, has she paid?
She has not. She is prepared to pay the $1,960. She is disputing the statutory interest that was alleged. She's also disputing the mileage and lost wages to attend these hearings that the plaintiff is alleging. As we stated in our motion, the plaintiff was ordered to prepare the order after the February hearing in 2020. He did so, but then never noticed out the signed order. My client did not receive that. However, at that hearing, she was ordered to send him certified mailing, telling him when she would pay. She attempted several times to send a certified mailing. We have that envelope with the rejections from the plaintiff, with the multiple stamps from the post office that they tried repeatedly over the course of several months. He would not accept that certified mailing. He will not communicate with her. He stated at his motion hearing on January 17th that he, in fact, stopped talking to her on advice of a friend. So it's just in direct contradiction to what he's been stating this whole time. He failed to serve her with that order. He failed to accept the certified mailings. He himself has admitted he won't communicate with her. So we are disputing the statutory interest. We are disputing the mileage and the lost wages. These hearings are on Zoom. There's no mileage necessary. We're on Zoom for a few minutes. We don't believe that's appropriate, but she will, in fact, pay the sum of $1,960.
Okay, and what is, you say you're disputing the interest to us. Was it an incorrect amount of interest, percentages, or calculation?
We're disputing it as a whole, Your Honor, based on his failure to serve her with the signed order and his refusal of the certified mailings that she was ordered to send him.
Okay. Okay, Mr. McGruff, what's your response? You're muted.
Yes, Your Honor. So this is my third time here to talk to you. Sorry it's taken that long. I just wrote down what I wanted to say. I addressed all of her things. So is it okay if I just read it to you?
Go ahead. As long
All
as
right,
it's
so-
not as long as it's not a novel, okay?
I got you. Reader's Digest version.
Yes.
So I received this appearance from this attorney on Saturday evening, late Saturday, 4 o'clock this Saturday. So I've had like a day to look at it. I didn't even know it was in my mailbox till this morning. So I just asked that we all can agree that Ms. Maines, through her words of her attorney on lines 1, 2, and 3, and 4 of her motion, that she owes this debt of $1,960, which the attorney just stated she did. The rest of this is just typical communication of my ex-wife and why she's my ex-wife. It's just a lot of deception. But I also looked up and, under proof of service under Rule 2.104, proof of service, it states that under Section B, failure to file proof of service does not affect the validity of the service. I mailed her notice and I mailed her the 7-day, the same day as the hearing that you issued it on the 27th, notice of entry under MCR 2.602B3. I sent her all that. I've seen her multiple times since this. I've seen her at least 10 times in person since this. Both of my daughters graduated. She did speak to me, but every time she speaks to me, it's about what Jerry Maines does for her and what I don't do as a father. It's been very toxic. So when I talked about miscommunication, that's quote is not accurate, what is stated in her motion. The actual date is July 28th, 2020, which was months after this happened. We had still been communicating, but every time I try, she gets so upset. She just called me the day we had the hearing, the last hearing, Your Honor. She called me at work 4 times. I answered it because it said no caller ID. When I got on the phone, she said, "It's your effing ex-wife." And I was on speakerphone, so I had to mute it. I was in front of 2 doctors. I'm a psychologist and therapist and social worker. So I just immediately terminated it. She called me back 3 more times, so my phone sat and vibrated. She left a message on my thing about, "I simply want to talk to you." And then she gets very, very excited and really nasty. So I don't talk to her anymore. It's toxic for me. I have to take care of these kids every day. As far as the what I filed, I just followed the law. I'm wrestling. I might pronounce this right. Proper. I'm doing this myself because there's no need to have an attorney. You issued the order. I'm just trying to enforce the order. The only thing this is hurting is her children and myself, which is all she cares to do. And then the last reference I have, as far as unclean hands that Ms. Podolsky references, I think it's misrepresented. I am not, I've Googled it. I've done a lot of research. I have a couple degrees. I'm not a dummy, but unclean hands has been evoked in the past to dismiss claims where litigants have used underhanded means to advance their cause. I do not, nor did I intend to advance my cause. The civil statutes indicate that should be able to have my debts. And I quoted it for you, MCL 600.6013, Section 8. That I have the right to do that. And so I calculated it based on the best knowledge I could understand. My last thing I want to say is I'm not trying to underhand the means to advance my case. I'm just seeking justice. And in my college career as a criminal justice graduate says that it's ethical, philosophical, and we're being treated impartially, fairly, properly, and reasonably by the law and arbitrators of the law. And the laws are to ensure that no harm befalls another, and that the harm is alleged, a remedial action is taken. I'm just seeking remedial action. Whatever that justice is in your courtroom, Your Honor, I am willing to live with. But I followed what the law said, and I Googled and spent hours on this, preparing this. That's all I'm trying to do. I'm not trying to underhand anybody, and I do not have unclean hands in this.
Okay.
That is not true.
Well, what the court's going to do is there's not a dispute as to the $1,960. the court's going to order that that amount be paid as well as the statutory interest. I'm not going to award the mileage or the other time, et cetera, in this particular matter, but we'll order that amount be paid. And I'll order that it be paid within 14 days of today's date. So, Mr. McGruff, you can prepare an order, submit under 7-day that the $1,960 as well as statutory interest would be paid within 14 days of today's
Court will note the
date.
appearance of Ms. Podolsky on behalf
the
of the
statutory-
plaintiff.
This matter is before the court on the defendant's motion to set aside referee order. Mr. Glasper, in this matter, you can't set aside the referee order just because you don't like the result. You're going to have to establish that there's a factual or legal error that the referee made in this matter. I do note your objection was that you took plaintiff back to court for more time and you got less, and you were ordered to pay support as well. What legal or factual error did the referee make?
I work real estate, and the days he gave me, I do like house showings and have to deal with clients, and I would have to take my kids to those. And that happened on February 1st. I took my kids to a showing, and that's not, I don't get my time with them. They went to work with me.
Well, that's kind of your issue. You're going to have to work your work schedule around the time you have the children, because we don't know when you work, and in a given week, especially with real estate, that changes from week to week, sometimes day to day.
So what do I do? Like, do I just give up my rights? Because I'm bringing it to court, and I feel like y'all just not helping me. Like, all I want to do is see my kids, and y'all got me paying $900 a month to not see my kids for real. 4 hours a day when I get them ain't really no time. So what do I do, man? I'm really trying to see my kids, and y'all making it seem like I'm a bad person. Like,
Well,
I don't know what I've done.
Bad person. That happens. The referees put in place an order that provides you to have time with your children. Now it's up to you to make sure that you can have.
But he didn't
that time.
accommodate. He didn't accommodate me for the time that I lost, that she was keeping them from me and stuff. So what do I do?
Well, what you have to do is establish why you believe that the referee was in error. Just because he didn't give you what you want doesn't mean that the referee committed an error. The referee has to take into account, various things, takes into account what the plaintiff states as well. And based upon that, they weigh the evidence and then they come up with a ruling. And
so I lost a year with my kids. She said CPS gave her a no contact order for me not to see my kids, and that's not true. What do you mean? I'm not understanding. Okay. Time was supposed to be made up, and it was supposed to be a lot of things that happened.
Well, it's not supposed to. You asked for it. There's no supposed to. Okay, let me go to Ms. Podolsky. Ms. Podolsky, could you enlighten the court?
Thank you. We had a full evidentiary hearing with referee Croteau. Evidence was presented, testimony was taken. The referee found there was not a denial of parenting time. In fact, the evidence showed that Mr. Glasper was not exercising his parenting time. There was testimony taken as to what the schedule has been since the court last put the order in place, what Mr. Glasper has and has not exercised, what Ms. Lawson has done, what she's done to accommodate him. There was also significant testimony taken as to the employment of both parties. I understand he's alleging he works in real estate. However, he testified to a full-time job and that he hasn't really started his real estate career yet. So I'm a little confused as to why now all of a sudden the schedule that the referee has given won't work. Based on the testimony and evidence presented that day, the referee made a ruling. He addressed the custody factors as well as the parenting time factors and the established custodial environment. He came to a conclusion, and this is the schedule that was put in place along with a child support order. We do not believe that there was a clear and concise statement of fact or finding an application of law that was made in error pursuant to court rules. So we do believe that this motion should be denied.
Okay. Mr. Glasper, what's your response?
Do I just fill this joint thing out and turn this in? Because I don't know what else to do.
Okay, well, what happens is, again, as I stated, it does appear based on what Ms. Podolsky had said that the referee had considered all of that. If you, in fact, have changed profession because you're no longer working the full-time job, but you're going into real estate, you have a right to file a motion to modify parenting time based upon that particular
I'm trying to
change.
get more time with my children, so I'm gonna file for joint custody, I guess. I don't know what y'all want to do.
Okay, you can file anything you want to file, sir. I can't keep you from filing that, but you're gonna have to establish a factual and a legal basis for doing so. So that's up to you. The court at this point doesn't see any basis to set aside the referee order in this matter, so the court will deny the motion and that
Okay.
order will remain in effect.
And we have a house together. How do I take her to court for that? Do I just?
You'll have to file a motion, sir.
Yeah, but what court is that? Like, is that civil court?
This court.
It's not
Okay.
this court. This was just a custody matter. This was
Oh,
not-
okay, that wasn't, okay. Yep, you'll have to file that probably in district court or, regular.
Okay, I'm
trial.
gonna file the joint in the house, and I'll be good.
Okay, okay.
Thank you.
Great. Court will end this matter at 10:53 a.m. You're free to go.
Thank you.
Got court for Glenwood? Yep.
Mute, Christopher. Christopher, can you hear me?
Hello?
Christopher Murray?
Hello? Yes, sir. Yes, ma'am.
Okay, are you here for a hearing with Judge Kirkham this morning?
I am.
Okay, what time was your hearing?
Yes, I can. I'm working on turning up my audio now.
Christopher, what
Yes.
time was your hearing?
Indeed.
What time was your hearing with Judge Kirkham?
As I understood, it was at 10:45.
What type of hearing was it?
Excuse me?
Hold on, let's see.
If it's 11:45 or 10:45, it must be a referee hearing.
Yes, I'm looking. Yes, I have you and it's already 251.
Thank you.
Referee Bradfield. So you're in the wrong meeting room. Christopher? Not sure where Christopher went. Serenity?
Yes, ma'am.
All right.
Mr. Murray's still on my screen.
Yes.
Mr. Murray, you're before the referee, so you have to connect to his meeting room, not ours. This matter is before the court on the defendant's motion to set aside a referee order in this matter. Mr. Grayer, it's incumbent upon you to establish that the referee has made a factual or legal error in this particular matter. It's not sufficient that you disagree with what they ruled. You're going to have to establish that they made an error. What is the error that you believe the referee made?
The error that was made was based on her report that was turned in, which the motion indicates that I quit my last place of employment, which was incorrect. I was actually terminated for my criminal record. I was actually working through one of the temp agencies. I worked at the location for a year. When my boss informed me that they wanted me to hire me in permanently, I filled out the application. A background search was done, and I was terminated immediately. for my criminal record. So that's one indication. I believe her decision was based on faulty information that maybe she had received, or I don't know how she got that information. In addition to that, Your Honor, the motion also indicated that I was terminated from the LEAP program, which was also inaccurate, Your Honor. I both times I was in the LEAP program, I volunteered for the program, just trying to get a leg up and kind of get my feet on the ground, so to speak. It's been last year and a half has been rather difficult time in my life at this point. But at any rate, that was inaccurate also. I withdrew from the program due to time constraints and budget constraints on the LEAP program behalf. So I withdrew from the program. It wasn't for not seeking employment. She recommended that I be enrolled in the program and in this last meeting, and I've been participating, doing the work searches, so on and so forth, and working diligently with them.
Okay, well, let me clarify a few points, sir. First, I looked at the referee's finding. The referee finding acknowledges that you were let go from that employment. So that would just basically again confirm that you didn't quit, but you were let go. Also, the court will note that the order of January 10, 2023 does provide that you have to participate in the LEAP program, and you haven't done it. So there's not an error on the referee's part there.
I'm participating in the LEAP program now. I'm sorry, I didn't catch that date. You said I was ordered to
January 10, 2023.
No, I wasn't ordered, Your Honor. I
well,
never went before.
It's in the order.
Oh, okay, yeah. That was last month. Yeah, and I'm in the LEAP program now, Your Honor. I've been in the LEAP program since that order was put in place in order to follow the courts or guidelines until I could get in front of you and so on and so forth. I have no problem with participating in the LEAP program. I think it's a great program. I've been participating as ordered thus far, Your Honor.
Okay. Well, at this point, sir, what I do is I look over the facts. I can't see that the referee made a legal or factual error in this particular matter. As I said, they acknowledged that, again, that you were let go. So clearly that confirms what you were stating, that you didn't quit, but you were let go. But that doesn't change the referee's determination in this particular matter. So if you can establish why that would, then the court will consider it. But I'm not going to consider it just because, based upon what you're saying, that's the fact.
Sir, excuse me.
So I would need actual documentation as to why I was terminated from the job in order.
But it doesn't matter. She acknowledges that you were terminated.
Oh, okay. All right. Well, when I read okay. All right.
Ms. Linwood, you wanted to say something.
Sure. Why is he doing the LEAP program? What is this about child support? Because
the LEAP program is a program that assists people in getting employment and working. So that's why he's in the program.
Okay. I've put in multiple paperwork to get the child support taken out of the situation. I'm not sure why I haven't received anything back. Well, before I was incarcerated, I did receive one paperwork to my mother's house, and that paperwork I was to fill out and send back in to start the process, and I hadn't got to that. Okay. But as I've been in jail,
let me ask you this, ma'am: is either of you receiving some sort of public assistance on behalf of the children?
I have asked the DHS to stop the medical assistance for Angel Linwood, and they should have done that. They should have.
Let me tell you, if in fact, when you do terminate public assistance, which would be the Medicaid from what you're saying, if that's terminated, then you have a right to terminate any support obligation that you want. You can't terminate the amount of arrearage that's owed to the state of Michigan, though. So you have a right to do it yourself, but you can't bargain away the monies that are owed to the state.
Right, only the outrageous that is owed to me, I can. So
Yes.
I'm aware that they started the process, but nobody has contacted me since I've been incarcerated. I have
Okay.
sent out a kite for child support, but nobody has responded to my
Okay.
kite.
When are you gonna get out? Do you know?
I have court April 3rd.
Okay. Well, what happens is you can contact the front of the court. You can contact your enforcement officer, state that you would like to, again, forgive any arrearages that's owed to you, as well as any current support obligation that might be owed to you. That would take care of that particular matter.
Okay, I'm kind of surprised you don't have that in your system. You don't see anything of this matter on your paperwork, because this
I don't have in my system, I don't have the stuff that the front of the court does, so I don't have any of that.
Okay, because I've asked them, this was supposed to be.
Well, I'll follow up with your enforcement officer, and then they should be able to take care of it.
Okay, can you provide me some information so I can send in a kite?
You'll have to just go to the front of the court. I don't know who your enforcement officer is or anything of that nature.
Okay.
Just
So
one quick, I know you're busy, but
what?
Just one quick last thing, Your Honor. I know you're busy, you got a busy schedule. I was informed that there was some type of custody change, and I'm aware of the child support amount was taken from Serenity, the child's mother, and redirected to a Rodney Beckham, who is not her biological father, nor is he Serenity's father.
Okay.
Serenity, when she was out, this was just a month and a half ago, went to obtain custody of our daughter, Angel, to get our daughter, and her and I were going to work out, her well-being between ourselves, and he would not give the child back. Now, was there a change? Do you have something in your records where there was a change in custody? Because if you don't, then
sir, all I have before me today is your motion. I don't have the entire file. You'll have to contact the clerk's office and check to see what orders are in place. And if there's an order in place, or if he has guardianship pursuant to a probate court order, then that it would be in the probate court. So you'll have to follow up on that to see what's happening in that regard, but I don't have that before me today.
Okay, I went to civil, I went to the FOC, I went to the probate court you're speaking of. They said they have nothing in the records.
Okay,
so
go to the circuit.
I'm just gonna go get my daughter and wait for my child's mother to get out and
go to the circuit court clerks, and they can inform you if there's any particular orders for custody.
Okay, well, when she went, she had to call the police, so on and so forth, and they said they couldn't do anything about changing custody of physical custody.
We've went and did the process together.
Right. So
well, okay.
I just want to go get my daughter and without any, and I wanted to do it the legal way. And so, as far as you know, there's no change in custody.
Sir, stop. Not as far as I know. I don't have the file, so I don't know. I'm not telling you, ma'am, stop. I'm talking to Mr. Grayer now. I'm not telling you have the right to do that. I told you have to go to the clerk's office, look to see if there is any order in place. And if not, you'd have to look in the probate court. There may be a probate court guardianship, which I don't have the probate court file. So you're going to have to make sure that you do that, because if you in fact take action and there's other orders in place, you could be in violation of those orders.
Yeah, that could be a criminal charge of some sort. Okay. And that's why I wanted to come in front of the courts or whatever. One of the reasons to kind of get that cleared up, but I'll follow your advice and go from there.
Okay. The only issue I have is the issue of setting aside the referee. There's not been established any factual or legal basis, so I'm going to deny your request. That will conclude this matter at 11:09 a.m. You're free to go. Court will note that this matter is before the court on the plaintiff's notice of entry of proposed order to enforce judgment in this particular matter. What is your Ms. French, what is your opposition to the order, if any?
I have no oppositions. I had called from the court and they said I did not need to sign as it was a 7-day order, and a 7-day order does not require my signature.
Okay, well, as long as you're not opposed to that, the court will enter the order as submitted by Mr. French in this matter. And that will conclude the matter unless you have anything else, Mr. French.
I was wondering, Your Honor, if that photograph copy that because what I submitted to the court was the actual piece of paper that she gave me on pickup and drop off. And so I'm trying to understand if that letter is, if the court is going to honor that letter, or if the defendant needs to reissue a new letter.
Courts don't honor letters, it's only orders. So if there's an order, the court will again enforce the order, but we don't enforce letters or anything of that nature. So
Judge, we do not have an order.
oh, okay.
We do not present an order for entry.
Okay. Okay, so sir, because you filed the notice of entry, you're going to have to submit an order so that we can in fact enter that. You did a notice for entry, but there was no order included with that, the best we can tell, or at least that I could tell.
Okay, I will reissue it.
Resubmit it, sir, and then we'll get that entered.
Your Honor, can we address this issue here? I got the letter. The best I could do was get a picture sent and have it printed, and that is what I received. What I handed to Mr. French, if he wanted a better copy, he could have asked me personally instead of bringing it to court.
Okay, well, I do note that when I saw that order that it was illegible, at least I couldn't read it. So
the copy he received was legible, and I do have another copy of it. I'm in the process of moving, so he's going to have to wait at least a week or two before I can get a new copy.
okay, sir, do you have a legible copy that you can submit?
Of the photo?
No, of the order. Of the order.
I can reprint it and
Okay.
send it.
Do that, resubmit it to the court, and then we'll get that entered.
All right, sounds good.
Okay,
Your Honor.
thank you. Court will conclude this matter at 11:13 a.m. You're free to go.
February 13th, 2023 at 11:13 a.m.
Court will note the appearance of defendant in this matter. This matter is on before the court on the defendant's motion to set aside referee order. We had a companion case by Mr. Grayer, and we addressed many of the referee findings in this particular matter that simply appears that this is a reiteration of the earlier case involving Linwood versus Grayer. Is there anything additional as it relates to Garrett?
No, sir. No, Your
Nothing?
Honor, there isn't.
Okay. The court would, if there's nothing additional, the court would make the same finding in this matter that I had in the companion case as there are the same issues. So the court would make that same finding.
Understood, Your Honor.
Okay, thank you, sir. That will
right.
conclude the matter at 11:14 a.m. You're free to go. Have a good day.
Yes, sir.